bon après-midi.
Good afternoon, everyone. Welcome to the meeting number 104 of the House of Commons Standing Committee on Industry and Technology. Today's meeting is taking place in hybrid format pursuant to the standing orders. Pursuant to the order of reference on Monday, April 24th, 2023, the committee is resuming consideration of Bill C-27, an act to enact the Consumer Privacy Protection Act, the Personal Information and Data Protection Tribunal Act, and the Artificial Intelligence and Data Act. And I'd like to welcome our witnesses today, and at the same time apologize for the delay. We had a vote at the House today. We have the Commission d'accès à l'information du Québec, or the Quebec Information Commissioner, Diane Poitras, who's the president. Thank you for being here. We have the Office of the Information and Privacy Commissioner of Alberta, Diane McLeod.
And Madame McLeod is accompanied by Caroline Stelmack, Assistant Commissioner, Case Management, and Sébastien Pawa, Manager for Innovation Technology Engagement, also by video conference. And at last, we have Michael McEvoy, Information and Privacy Commissioner for the province of British Columbia. Thank you to the three of you for joining us today. We have until 5 p.m. today, and so without further ado, I would cede the floor. Je céderai la parole à Madame Poitras pour ses remarques préliminaires.
Madame Poitras, you have 5 minutes for your opening statement. Thank you, Mr. Chair, and thank you to all the members of the committee for this invitation. As you know, Quebec has carried out a major reform of its privacy laws so that they are better adapted to the new challenges posed by today's digital and technological environment. The Act to modernize legislative provisions respecting the protection of personal information, better known as Law 25, was adopted in September 2021. Its provisions have come or will come into effect gradually over a 3-year period. The changes introduced by Law 25 can be grouped into 3 categories: new obligations for companies, public bodies, and provincial political parties. Secondly, new rights for citizens, and new powers for the Commission d'accès à l'information, or the Commission. Among the new obligations of for companies is the addition of the principle of accountability for the personal information they hold. This implies that each company must have a privacy officer and establish policies and governance practices. Companies are also subject to new obligations in the event of a privacy incident, similar to those found in Bill C-27. Law 25 also introduces greater transparency about what companies do with personal information. To give citizens greater control over their privacy and personal information, new consent requirements have been introduced, such as express consent for sensitive information. To be valid, consent must also meet certain conditions, be requested in clear and simple terms for each purpose and separately from any other information. The law also provides for measures to prevent breaches of privacy, such as the obligation to carry out a privacy impact assessment at the design stage of products or technological systems involving personal information. This type of prior assessment must also be carried out before personal information is communicated outside of Quebec to ensure that it is adequately protected. If an organization collects personal information by offering a technological product or service, privacy settings should, by default, be set to those that provide the highest level of protection. The law also regulates the collection and use of particularly sensitive information and certain situations presenting a higher potential for intrusion, such as profiling, geolocation, biometrics, and information concerning minors. As for new rights for individuals, they include the right to be forgotten, the right to portability of information, and certain rights when a fully automated decision is made about them by an artificial intelligence system, AI. Finally, the Commission has been given new powers. It is the body responsible for overseeing the application of laws on access to documents and the protection of personal information, and the Commission is also promoting these rights in Quebec. The Commission has had the power to issue orders since its creation. It may also, with the authorization of a judge, institute criminal proceedings for an offense under the laws it is charged with supervising. Law 25 significantly increases the penalties that can be imposed and lengthened the time limit for bringing such legal proceedings. The Commission now also has the power to impose administrative monetary penalties of up to several $million. It can adopt guidelines and has enhanced investigative powers. Bill C-27 have similar aims to those that motivated the Quebec reform. For businesses, the consistency of the rules to be complied with in the various jurisdictions in which they operate will help reduce their regulatory burden. The adoption of similar interoperable rules facilitates the essential work of collaboration between the various supervisory authorities across the country, but also internationally. At the end of the day, however, it ensures that citizens' fundamental rights are respected and increases their confidence in the digital economy and the use of new technologies such as AI, thus fostering responsible innovation. In closing, I would like to point out that over the past few years, we've been engaged in a nonpartisan, transparent, and inclusive collective reflection on the framework for artificial intelligence. This happened in the last few months in Quebec. More than 200 experts, including the Commission, examined 6 themes, and a call for public contributions completes the reflection. The preliminary orientations emerging from this work were discussed at a public forum last month. Recommendations on the framework for AI will be submitted to the Quebec government by the end of the year. Thank you, and I'd be happy to answer any questions.
Merci beaucoup.
Thank you very much, Mrs. McLeod.
Good afternoon. I would first like to thank the committee for inviting us here today as witnesses to your proceedings on Bill C-27. This bill is an important step in modernizing Canada's privacy sector privacy law. It will support responsible innovation and development of innovative technologies while adequately protecting privacy rights. Innovation is occurring in all sectors. These activities benefit Canadians, but there are also risks. This law will play a key role in establishing a foundation of trust amongst Canadians, which will foster the growth of our digital economy. Alberta's Personal Information Protection Act, or PIPA, has been declared substantially similar to the Personal Information Protection and Electronic Documents Act, or PIPEDA. The objective of PIPA is essentially the same as PIPEDA's, and both acts are consent-driven with certain exceptions. Given these similarities, I will not go through PIPA in detail. Instead, I will focus on an aspect of PIPA that may be of interest as you consider the Consumer Privacy Protection Act portion of Bill C-27, specifically our order-making power. Most reviews and complaints are settled by our informal case resolution team, which is about 85%. If settlement fails, the commissioner may conduct an inquiry, a quasi-judicial process, which involves formal submissions to an adjudicator, who then issues an order to remedy any non-compliance. Our informal case resolution team operates separately from our adjudication team. When a file moves to inquiry, our adjudicators conduct a de novo hearing. They do not have access to what occurred in mediation. Orders are final, binding, and not appealable, but they are subject to judicial review by the Alberta Court of King's Bench. The majority of our orders are complied with. We have sought a court order to enforce compliance in only a few cases. This structure brings finality to allegations of noncompliance in a cost-effective, predictive, and relatively timely manner. Finality serves several purposes. It creates certainty around the interpretation of PIPA, which serves both the interests of organizations and individuals. It encourages settlement. Because our services are free, our office is fully independent from government, and the majority of our orders are complied with. This reduces the time it takes to remedy noncompliance. PIPA is scheduled for review by our Standing Committee on Resource Stewardship, likely to begin early in 2024. Given this, we've been paying close attention to what is happening with Bill C-27, specifically the CPPA, as it may influence amendments to PIPA due to PIPA's substantially similar status. We are also considering the impact of Bill C-27 on Albertans when their personal information flows across borders. In the CPPA, there are positive new privacy protections for Canadians. There is the right to request disposal of personal information, also known as the right to be forgotten, rights regarding the use of automated decision-making systems, and rights regarding data portability. Other improvements include clarifications of service providers' role and accountability, administrative monetary penalties to deter noncompliance, proactive auditing, better protection for minors, and the inclusion of privacy as a fundamental right and the special interests of minors proposed as amendments. However, we have some concerns regarding a few provisions. We are concerned about individuals' loss of control over their personal information resulting from new authorities in Section 18 regarding business activities and legitimate interests. We are concerned about how the provisions on de-identification and anonymization will be used and whether this requires more controls to mitigate potential risks to individuals. We are concerned about whether the inclusion of the tribunal as an appeal body to the Privacy Commissioner's orders will impact our ability to conduct joint investigations. In addition, there are areas in the bill that could be enhanced, including building in stronger protections for children, such as those provided for in California and the United Kingdom, requiring the use of privacy impact assessments in specific circumstances where there are higher risks, increased rights for the use of automated decision-making systems, and expanding the definition of sensitive information to mitigate the risks of harm that may flow from the processing of certain kinds of personal information. I thank you for your time, and I look forward to further discussion.
Thank you very much, Madam McLeod and Mr. McEvoy. The floor is yours.
Thank you, Chair. Thank you, Chair, members of the committee. I'd first like to acknowledge that I'm presenting to you today from the traditional territories of the Kwanghan-speaking people of the Songhees and the Esquimalt First Nations. Given my brief time this afternoon, I wanted to focus my comments on the practical matter of how the privacy rights of Canadians ought to be considered and, where events dictate, enforced. A common theme of these proceedings, I think, is the need to harmonize to the greatest extent possible the substantive privacy rights of Canadians across federal and provincial jurisdictions. The principle of harmony or substantial similarity should also apply to the processes that determine and enforce privacy rights. Why is this so important? Data most often knows no borders. Many significant privacy rights cases impact citizens across the country. It is therefore incumbent upon us as privacy regulators with oversight over the private sector in Alberta, British Columbia, Quebec, and Canada to act to the greatest extent permitted by law in a coordinated manner. This ensures that concerned individuals are addressed in a consistent way and affected businesses are not queried by overlapping demands. In short, coordination builds the trust of Canadians in our privacy oversight system. The coordinated actions I speak about will be enhanced considerably if the avenues for processing and enforcing those privacy rights are as consistent as the law permits across jurisdictions. In concrete terms, this means that the Federal Privacy Commissioner should certainly be granted order-making powers, which the three provincial authorities now have and which Bill C-27 recommends. I would go a step further. The proposed federal order-making powers should be reviewable in the same manner as that applicable to provincial authorities. That is to say, the Federal Privacy Commissioner's powers should be directly subject to review by the courts. That has proven more than sufficient to protect the rights of all parties at a provincial level. Bill C-27's proposal to add a layer of administrative bureaucracy in between the Commissioner's orders and court review adds an unnecessary level of expense and time to distance Canadians further from the ultimate disposition of their privacy concerns. The same considerations of federal-provincial harmonization should be applied to the matter of administrative monetary penalties. Quebec, as my colleague has just pointed out, is the first jurisdiction in Canada to authorize the regulator to administer such penalties where circumstances warrant. I have called for British Columbia's government to do the same. The authority to levy fines, a last resort for regulators, protects the rights of Canadians and the vast majority of businesses from bad actors. It is critical that privacy regulators are able to ensure that when fines are necessary for multi-jurisdictional violations, they are levied in a coordinated, proportionate, and non-overlapping way. That is simply not possible under Bill C-27, which strips away power from the Federal Privacy Commissioner to levy fines and instead puts it in the hands of a third party that would not be in a position to coordinate matters with other authorities. This again creates federal-provincial asymmetries, which in no way benefits Canadians. It bears repeating that if a party were concerned about an imposed fine, a direct referral to the court system is more than adequate to ensure administrative oversight of the system. In summary, while Bill C-27 goes some ways to strengthen the privacy rights of Canadians, the bill must be improved to ensure that those rights can be fairly, effectively, and economically adjudicated and enforced. With my colleagues, of course, I welcome any questions you may have.
Merci beaucoup. À vous.
Thank you very much for all three witnesses. First of all, Mr. Généreux for 6 minutes. Thank you, Mr. Chair. Thank you to all witnesses. Mrs. Poitras, nice to meet you. First of all, I would like to congratulate Quebec's government and your organization for the work that was done. Since the beginning of our study on Bill C-27, many called Quebec's law a model. So congratulations for this. I'd like to ask my first question. That is, were there consultations in Quebec that were done prior to tabling the law? I had understood earlier that you are currently in the process of consultations. There are 6 streams of consultations. Did you do that before the adoption of the law in Quebec? Answer, yes, there were consultations held by a commission of the National Assembly in Quebec where many stakeholders were able to express themselves, both from the private sectors, the civil society, and citizens' participations. This consultation was asked the following: how can we give a framework for AI? Question. So in the process that led to the adoption of the law in Quebec and compared to the process that unfortunately was not done here, were you able to compare Bill C-27 and the law adopted in Quebec? We speak much about the priority where the bill will take priority in terms of the application of the law legally. What is your analysis regarding this question? I know that there are certain reservations regarding to Bill C-27. Do you also have these reservations? Answer, yes, there are certain concerns. I share my colleagues' concerns about the interoperability of the bill. Without the obligations being exactly the same, it is imperative for Canadian citizens to receive similar levels of protection no matter where you are in Canada, but also for businesses. Currently, businesses can operate in Quebec, but not in Canada. And this is a concern that was often expressed to us in Quebec, the concern that at the time there was Bill C-11, that there's no harmonization and that they must play by 2 different rule books, and for their activities, it can be challenging. I don't know if I've answered your question. Well, sure. I'm myself a businessman, an entrepreneur, and relative to the law in Quebec, and I'm not full-time, of course, so I'm not aware if I'm a compliant, if the compliance is good. Of course, I work in communications. Is there a minimal number of employees? How do we assess how Quebec businesses must be compliant with? And of course, we're always comparing to what's in Bill C-27 and not in Bill C-27. Could you specify? Answer, yes. For the first question, businesses are subject to Quebec law. So any businesses that has organized business activities and that collect or communicates or keeps personal information in Quebec. And therefore, it's quite broad. This includes commercial operations, but also other types of businesses and enterprises, no matter the size of the business. They're all subject to that law in Quebec. So I think part of your question, if I understand correctly, is do we have concerns relative to the interoperability of these two, the law and the bill? Yes, I do have concerns. There's a significant distinctions in the applicable regime in terms of there are certain distinctions. I could speak to them a bit further later. There's also administrative legal fines that can be applied, and the absence of some preventative measures for the usage of technology, such as the absence of using factors relative to profiling or privacy. So, question, what recommendations would you have to amend C-27 to allow for interoperability between jurisdictions? Currently, British Columbia also has concerns. I asked also questions to British Columbia and Alberta and asked the colleagues. We're trying to see how we can improve Bill C-27 so that we can address these concerns and answer to all the actors in this committee. We want to have interoperability for all jurisdictions for all of Canada. Answer, yes, thank you for this question. I would like to first say that Commissioner Dufresne had excellent recommendations regarding harmonization. If I talk about the anonymous information, I know there are many stakeholders in front of you that will tell you that the definition of anonymity was quite limiting in Bill C-27. Compare that with Quebec. After discussions with parliamentarians, we've included an additional clause that we should always prevent whenever it is reasonable. Of course, this was introduced. However, parliamentarians are concerned that we don't open too big of a window. And also, at the same time, we've adopted that we can impose certain criteria, modalities in terms of how we do this harmonization. The depersonalization is also an issue because using depersonalized information is sometimes depersonalized information is no longer depersonalized. So there's also fines that can be levied. My colleague, Mr. McAvoy, has presented the concern quite well, but also the scope of these fines. So it's quite limited in C-27 when the federal commissioner would be able to recommend to the tribunal imposing these financial fines. Thank you very much. Thank you, Mr. Généreux. Mr. Van Bynen, you have the floor.
Thank you, Mr. Chair. And it's great to see that we're having all of the privacy commissioners from different jurisdictions. If there's anything that we know about data these days, is that it tends to migrate across borders, not just provincially but internationally. My first question is to each of the three attendants here. Section 9 of the Consumer Privacy Protection Act would require that each organization subject to the Act would maintain a privacy management program that includes policies, practices, and procedures that it has in place to meet obligations under the Act. And I'll start with Madame Portraz. Do provincial organizations already, are they required to develop a privacy management program, and how is that monitored?
Yes, thank you. Law 25 has an obligation that came into effect since last September. This does not apply to privacy management programs. It's called an obligation to adopt governance rules, policies of governance. But it's the same thing. When we look at the content, it is corresponding to what we see at the federal level or with British Columbia, the same types of obligations.
Organizations?
Excusez-moi, j'ai pas compris la question.
Sorry, I didn't hear the question.
In your opinion, is that too onerous on some organizations? We had earlier had some discussions about what size of organization should all of these rules apply to.
En fait,
Well, in fact, this is the basis to develop a culture of privacy protection. It can be adapted to the size of the business or the type of personal information that we process in the enterprise. It could be a very small enterprise, such as Fairview AI, that was very young, or it could be a startup. Many startups will use an important amount of sensitive personal information. So this obligation does not depend on the size, but rather we modulate it depending on the usage or the sensitivity level of the information.
Yes, I would just second what Commissioner Poitras has said. In British Columbia, we have a similar provision that requires organizations to develop and follow policies and practice, which ensures that they're consistent with our legal framework. We describe that requirement and obligation as being scalable. We wouldn't expect, obviously, the same thing of if I can use the term mom and pop corner store as we would from a significant corporation with thousands of employees. These things will be scaled. Not to say, by the way, that smaller entities nowadays couldn't handle vast amounts of information and very sensitive information. So our expectations obviously would be higher. But the obligations are scalable. And I mean, all companies now need to be thinking about these issues because Canadians, customers, patients, all kinds of people are concerned about how their data is handled, and trust on the part of those individuals in companies and others that they deal with is fundamental to, I think, to any business.
Same question then to Ms. McLeod.
Thank you. I think my colleagues have covered it quite well. And several years ago, the BC, the Federal Privacy Commissioner in Alberta, developed a building blocks, for privacy management programs, which we have referred to since its inception. I think it was in 2015. There are requirements in PEPA. There are certain aspects of privacy management programs that are codified within the legislation. You are required to have policies and procedures, and you need to have a contact person. I think what you'll see is that as you look at modernized privacy laws across jurisdictions, that privacy management programs are becoming a standard. And it's becoming a standard, in my view, because it's needed to actually protect the information that is flowing through the data systems in industry. And you're right, it needs to be scalable, but it also has to be recognized that as we move ahead with the digital economy, and it's not slowing down, it's only increasing, and the novel technologies are going to be used by businesses of all sizes. And as my colleague, Commissioner McAvoy said, trust is the foundation of an actual successful digital economy. So it's necessary that this infrastructure is there in order to facilitate the use of these technologies and going forward.
Of talk about the ability to levy fines. And we've heard some substantial fines, but to my way of thinking, when you think of some of these multinational organizations, the fines in itself could simply be considered a cost of doing business. Are there any additional remedies that you would say the Privacy Commissioner should have? Example, disgorge the data that you've assembled, or to discontinue production?
Yes, so that's a very, very good question. And I think you're quite right. In some instances, it would be seen as a license to continue doing what companies are doing. I think the most effective remedy that the government can provide in legislation for its regulator is order-making power. Because the three of us that you're seeing here today, we actually have the power to say to a company or an organization, stop doing what you're doing. Which is a far more effective remedy in some instances where that action or conduct on the part of an organization may be harming Quebecer, British Columbian, Albertans, Canadians, that remedy is the most effective. And so I know Bill C-27 now puts that order-making authority in the hands of would put it in the hands of the commissioner, which is a very positive step. But as we've indicated, if there's going to be any appeal, that should be directly to the courts, as we have faced over the years as a means of oversight over what we do.
Thank you. Yes, you are, Mr. Van Bynen. Thank you. Monsieur Lemire, la parole est à vous.
Mr. Lemire. Thank you, Mr. Chair. Thank you, Ms. Poitras, for your statement this morning, this afternoon as well. Thank you for innovation and the rigor shown by Quebec. I want to ask you a question. Even though the minister ensures that the Quebec law will prevail for the territory of Quebec, we still have concerns that were expressed at the committee by James Pasili, namely where C-27 will have inferior norms, standards, and this will compromise the inquiries in the Quebec economy. With that, how do you evaluate the impact in Quebec's economy relative to investment and innovation?
Oui, merci pour la...
Thank you for this question. It comes back to what we were discussing about interoperability. Of course, when a business needs to follow two sets of rules, because it is possible to apply both of these laws at the same time. Sometimes it can happen, and it may be the case in the future, but there are some cases where a business will need to follow both Bill C-27 eventually, and Law 25. And if the rules are not the same, it can be difficult to follow both sets of rules. Of course, there's a tendency to want to follow the lower requirements. That said, it's also important to be able to monitor and provide oversight in our various interventions for the whole of Canada. That said, the scope of the Quebec law is still quite significant. A business that operates and collects data or keeps personal data must be respecting the Quebec law. To include provisions specific to C-27 to get closer to the standards by Law 25 and to ensure better interoperability to the benefit of, and you said it, to entrepreneurs and bureaucracy that this person may have to do. Yes, so I believe for the whole of the provisions about anonymity and remaining anonymous, for me, it's a part of law of C-27 that I am concerned, that I'm especially concerned about relative to interoperabilities, and also the scope of fines. Also, the lack of preventative measures is a concern for the use of technology. The fact that we can do assessments prior to setting up a technology to make sure that we are compliant with the law and that there's no intrusion, an inappropriate intrusion to privacy, that is a preventative measure that is essential. The commissioner also recommended measures against profiling, encourage further transparency so that we also have the right to refuse. These are things that are in the Quebec law for these new technologies that I believe we can improve on for Bill C-27. You referred in your opening statement to the commissioner. I think it's the commissioner on human rights. I believe that's what I heard on the powers that they have in Quebec, namely the right to inform the public. Therefore, to have constraining powers. Do you think Bill C-27 could have similar mechanisms to protect Canadians in the dissemination of their personal information and to also educate them from a pedagogical sense? Yes, that is our role at the Commission d'accès à l'information, to legislate on these subjects. I believe that all of my colleagues in Canada, even though it's not written in their laws, they have this duty. It would be interesting to adjust it elsewhere as well. It's important for the commissioner to, of course, have the funds to be able to carry out this undertaking. That's also a preventative measure to inform the public, but also to inform businesses of their obligations and inform the public of their rights. Thank you. You referred as well to a summit on AI that was held in Quebec recently. Could you tell us a little bit more? We understand that there were recommendations published in the future, but what was the context? Who was invited and what was the mandate? Yes, of course. I'd be happy to answer that. It's the government of Quebec that mandated the Council of Innovation of Quebec to carry out a collective reflection how to frame AI, and should we frame AI, and if so, how so? And the Innovation Council worked on that project. There were 6 themes, as I mentioned. One of them was the governance framework of AI. So there was a group of experts, there were workshops, and there were discussions with each of with the experts for each of the themes. There was also a call for contribution that was public. Recently, in November 2nd, there was a public forum to assess the preliminary conclusions drawn from each of the groups and have a feedback loop. This will be preliminary recommendations and will be done before the end of the year by the Council of Innovation at the Government of Quebec relative to the framework for AI. Question, Mr. Chair, could you ensure that we could also obtain these recommendations once they are public? Yes, absolutely. Thank you, Mr. Lemire.
It's great to be joining the Industry Committee today and worked with a few of you, Mr. McDonald and Mr. V's, on protecting wild salmon, so it's always good to be coming to industry. And thank you. Yeah, got it. And thank you. And I do sit on Government Operations Committee, so I'm going to focus on things that are related to Crown corporations and government. And one thing, as the evaluation and analysis of this bill has progressed, the question about whether the government and Crown corporations should be included in the scope of the act has been raised. Could you maybe provide your thoughts on this and whether the government and Crown corporations should be included? And we know, like, Canada Post, was guilty of breaking privacy laws using personal information from outside, of delivered envelopes for a marketing program. And this was, according to the federal privacy watchdog. Maybe if you could speak to that, or if you can connect to that, Mr. McAvee, if you want to start and kind of open it up.
Yes, it's Mr. McAvoy.
I'm sorry, my apologies.
Perfectly fine. I've been called far worse. So,
because you're on Vancouver Island, so that's where I'm from. So,
so on the point of the public sector being covered, we are in British Columbia. The public sector is covered, so that's everything from the Crown corporations, which you've talked about, to a school board, municipality, all the functions basically of the public sector. The British Columbia government actually recently made changes to our Freedom of Information Protection of Privacy Act, which require public bodies now to produce privacy management programs, the thing that we just talked about in the private sector. We believe that's a very positive development. It means that every single public body in the province has to focus on what personal information they have about all of us, how they are going to deal with it if things go wrong, what the emergency plan is in place. As well, in the public sector now, there's a mandatory breach notification where when breaches happen, individuals are notified. So I think that those who, and of course, in the public sector, it's not a consent-based model. We as citizens really don't have much of a choice in most cases about giving over our information to public bodies to get the services that we require. So it's very important that the law carefully authorize that collection and that it be regulated. And we certainly believe in British Columbia that is done in a very effective way.
I want to add to that. Ms. McAfee? Oh, sorry. Ms. McLeod?
Thank you. Yes, we here in Alberta have three privacy laws, actually. We have the private sector privacy law that covers everything except for aspects of our nonprofit sector. We have our public sector privacy law that operates similar to what Commissioner McAvoy just explained. And we also have a health information law that governs the health sector in our province. So, we here in Alberta are looking at harmonizing our own laws as we are looking at advancing our digital economy here and using technology to innovate. So, we're looking not only in Alberta, but we're also looking, of course, at Bill C-27 as we consider what the landscape needs to look like.
Federal political parties are not included in this bill. Do you think political parties should be subject to the provisions of this bill?
Maybe I could start on that one if I may. It happens that British Columbia we're not the only jurisdiction because there's some application of the law in Quebec, which Commissioner Poitras can talk about, but we have essentially the full application of our Personal Information Protection Act applies to political parties. And we've utilized that aspect of the law to review how political parties in this province collect and use and disclose information about voters, which we think is really important. The short answer to your question is yes. In our view, my view, the federal law should apply to federal political parties. The basic reason is that it will enhance the trust between voters and all of our parties and the candidates seeking information from citizens. Those citizens will know that when they exchange views with their political parties, communicate their views, whatever information they give over, that is going to be it's going to be properly dealt with. And if there is an issue, there's going to be an independent oversight authority which can basically adjudicate any disputes. That can do nothing but enhance trust that Canadians will have in federal political parties, in my view.
Ms. Poitras, I'll go to you. Now, with the Biden administration's recent executive order on AI regulation, what is your perspective on how AI regulation has been approached in Canada versus the United States?
Answer. I believe there are several approaches we can use to offer a framework for AI. The important matter, however, I believe it is more and more consensus. There's more and more consensus, at least in Quebec, that we need to offer a framework for AI. And there's some limits to the law. We saw it until now. Therefore, I believe that the position in Quebec, or that of the Commission at least, I'd like to speak on behalf of the Commission's position, that we need a framework law with principles. In Quebec, we've adopted for several years the Declaration of Montreal. That is a declaration of principles on the responsible use of AI. But this is voluntary, and there was limits to that. The expert groups in which I was agreed that we need to go further, that we need to enforce more obligations to ensure the responsible use and development of AI.
And if members allow me, I just take 2 minutes to ask a little question because I'd like to do a bit of mileage on MP John's questions regarding political parties. Mr. McAvoy, I understand there's a case in British Columbia where political parties, the NDP, the Liberals, and the Conservatives are fighting your office so as to not be covered under PIPA. The Bloc, for some reason, is not contesting that. I guess they don't garner much information in BC, understandably. But so ma question serait plus pour Madame Poitras.
The question is more from Madame Poitras and Ms. McLeod. In Quebec and Alberta, what are the provisions where political parties are subject to conform to privacy laws? Could you give us, for the benefit of the committee, a brief summary?
Alors, je peux peut-être.
Sure, I can go ahead. This is something new under Law 25. The provisions are first in the electoral law, meaning that the electoral law in Quebec provides that the independent MPs and provincial parties must respect the provisions that are in the law concerning the privacy in the private sectors, unless there are specific provisions in the electoral law. There are a few. For example, there's no obligations to destroy personal information, and there's no right to access personal information nor ask for rectification when they are held by political parties. Of course, the Commission would have preferred that would be the case because there are many better ways to ensure to respect citizens' rights. Of course, here we're speaking about political parties so that citizens can know what is being done with their personal information. But essentially, most of the obligations applied for businesses are also applicable, but there's a limit by which, in terms of what political parties can use, it needs to be for voting means. Thank you. Thank you, Ms. McLeod.
In Alberta, the political parties are expressly excluded from the application of our private sector privacy law, PIPA. I don't know off the top of my head whether or not there's privacy provisions in Elections Act. There usually are. We are looking at this as part of our recommendations for our PIPA review, and we will be recommending that political parties be added to or be subject to the Personal Information Protection Act. So I'll have occasion at that point to look at our Elections Act and see what controls are in there.
Thank you very much.
And perhaps,
yes.
Sorry, and Chair, perhaps for a point of clarification, I should note that in British Columbia, there is no doubt that the Personal Information Protection Act applies to BC's provincial political parties. A ruling of our office held that federal political parties operating in British Columbia were also covered by the legislation. That is the point that is now in dispute before the courts, just to be clear, just that aspect.
Yes, understood. Thank you very much. I'll now get back to our regular programming. Mr. Viss, the floor is yours.
Thank you, Mr. Chair. Thank you to the witnesses today. Mr. McAvoy, just touching upon the current court case involving federal political parties, is your office pursuing oversight over federal political parties because the Liberal Party used artificial intelligence to identify possible participants in their nomination and candidate selection processes?
Well, first I should say that obviously I have to be very careful in terms of what I say about this case because it is before the courts now. I would say that the case was initiated because of complaints that we received from individuals who were seeking information. I'm just trying to recall off the top of my head. It may have been multiple political parties seeking certain information, and they didn't receive that, and so therefore they complained to our office, and that's what we were looking at. And then the initial issue was simply whether or not my office had jurisdiction with respect to federal political parties operating in British Columbia. Answer to that question, by my office was yes. And again, that matters before the courts. And so beyond that, I really don't want to comment about it.
That's fair. Thank you. The artificial excuse me, gentlemen. Thank you. The Artificial Intelligence and Data Act, or ADA, seeks to establish a framework by which we will further regulate at the federal level artificial intelligence. I noticed in your recommendations to the province of BC that you said there should be public guiding principles of AI in British Columbia. I believe it states that AI should apply, that AI regulation or principles should apply to all existing and new programs or activities, be included in any tendering documents by public authorities for third-party contracts or ADS delivered by service providers, and be used to assess legacy projects to be brought into compliance within a reasonable time frame. What I'm reading there suggests that the province of British Columbia has adopted a model similar to that in United States, where they received a public order that all government departments automatically begin ensuring that they are ready to handle the challenges outlined by artificial intelligence. Is that a correct assessment?
Well, my understanding right now is the British Columbia government is reviewing the principles by which it will deal with issues of artificial intelligence. I should say that on the regulation side of things, myself, along with the ombudsperson in British Columbia, have, as you note, set out some guidance that we think should apply. And I should say, by the by, we also strongly support Federal Commissioner Philippe Dufresne's proposals to ensure that where high impact significant matters of AI are being undertaken, that those be subject to privacy impact assessments. It's the same kind of provisions that, in our view, the British Columbia government should be using, and we will be consulting with the British Columbia government as they develop their principles and guidelines as to how AI will be deployed in the province.
Thank you. We've had some discussion here at this committee regarding what a high impact system actually would be. In your words, how would you define high impact?
Yeah, that's not terminology that we have used in British Columbia. I mean, anytime you're looking at a system that attempts to, first of all, gather large amounts of data that's used to predict, to profile people, that's involved in making decisions about people, I'm not sure how you scale that. To me, any of that that is involved in using data to make those kinds of decisions about people it impacts them. And there's a right to notification where those systems are in place. There should be a right to object. These are the concerns I know Commissioner Dufresne has raised publicly and with the committee, and we are very supportive of the recommendations he's making, that the amendments that he believes should be brought to bear on the federal legislation front.
To 2023 annual report of the Office of the Information and Privacy Commissioner, you highlight the importance of modernizing British Columbia's Personal Information Protection Act, which has not been updated since it came into force in 2003. What do you think are the most important elements of the modernized Personal Information Protection Act? And could any of your recommendations to modernize the Personal Information Protection Act apply to Bill C-27? If so, which ones?
Well, let me start with one area where British Columbia, in my view, is behind, and it's behind federally and my colleagues that I'm with today, and that is on the issue of mandatory breach notification. There is no obligation on private sector companies in this province to report to my office when there's a breach that would cause a significant real risk of significant harm. But most importantly, there's no obligation on those companies to report that to individuals who are affected. That is something that needs to be changed. There are a raft of other provisions that exist, very good provisions that exist in other legislation, including Quebec's. I think of Commissioner Poitras' ability to oversee biometrics in the province, which is it's a burgeoning area, one that impacts people significantly, facial recognition technology, all those kinds of things, where there's an obligation in Quebec to report the implementations of those kinds of programs. I think that's something that British Columbia ought to be looking at. the automated decision-making processes that are included in Bill C-27 should be, I think, incorporated in British Columbia as well. But I would urge British Columbia's government to go a step further than what's in Bill C-27. And again, Commissioner Dufresne has already alluded to those and where he believes, and we completely support, the improvements to those provisions.
So you would agree with
Mr. Viss, I'm sorry, you're
Thank you, Chair.
way over time. We'll go to Mr. Sorbara.
Thank you, Chair, and thank you to our witnesses for being here virtually. And I hope everyone is doing well in their respective areas of the country. I wish first to speak to Michael, and greetings to beautiful British Columbia, my home province and birth province for many, and home province for many years. I'll be out there to see my family, my folks, over the holidays. You did make a comment, and I do wish if you could start off on it in terms of order-making party or order-making ability. And I wonder if you could elaborate on that. Each of you have a very important, I would say, and in today's world where innovation and technology and data is, data is the new oil of the 22nd century, I guess, 21st century. If you can comment on that order-making ability.
It is a very important part of, and just one part of the toolbox that we have as regulators. Commissioner McLeod and Commissioner Peltois have talked about our role as educators, because that's kind of where things begin. Almost all organizations that I think we encounter want to do the right thing. And so part of our responsibility is to ensure that they understand their legal obligations, and once understood, businesses comply. So that deals with a lot of the issues that might otherwise have to be dealt with. Where organizations simply choose to ignore the law, and that's not in a very large number of cases, we have, as part of our toolbox of compliance, order-making authority, which simply, in many cases, means that we can order an organization to stop doing what is illegal, in effect, and to bring them into compliance with the law. That can ultimately be enforced in the court system. And again, it's an effective tool, an important tool. I think that all regulators, not just in the privacy field, but right across the board, regulatory authorities who want to ensure that the public are protected in so many ways.
Ms. McLeod, can you comment on that as well, please, briefly?
Yes, I can. I worked for a number of years in a jurisdiction where I did not have order-making powers, and it was fraught with challenges when bodies would refuse recommendations, and the only recourse was for the public to go to court, and of course that's unlikely to happen. So it's important from that aspect as well. It protects the public. It gives the commissioner the ability to require an organization to come into compliance with the legislation when they otherwise refuse to. And as I indicated in my opening remarks, the majority of our cases, 85% of them are settled by informal means. And referring to what Commissioner McAvoy said, most of the organizations either don't understand their obligations or, misinterpreted the law, and we can settle that quite easily through our informal case resolution process. So the orders are really the last resort, if you will, to bring an organization into compliance when they otherwise might not be if there's recommendation power.
Thank you. And can I get, for last comment, to Diane, please, s'il vous plaît.
Oui,
Yes, I agree with my colleagues. This is a power that encourages compliance to know that ultimately, if a business does not want to comply, we will be able to issue orders to take measures in order to comply. This will incentivize and render the work of the authorities easier in terms of oversight. And our powers are quite wide. In Quebec, we can make orders, any things that will encourage compliance. This includes destroying personal information to stop a practice. So our powers are quite large and quite broad, and all of this encourages compliance.
Thank you, merci. Just a quick follow-up question. In terms of Canada being a fiscal federation and sometimes the provinces lead before the federal government and vice versa, in terms of the Consumer Privacy Protection Act and Bill C-27, if I'm understanding this right, and please correct me if I'm not, in terms of a reasonable transition period, do you think it's important to allow provinces a regional transition period? Why or why not? I can go back to Michael and go back to the beginning on that.
Well, I guess the answer would be, I think it depends. I think you're quite right to say that in many instances, the provinces have been ahead of the federal government. I think of order-making power is one. The federal government brought in legislation first on the privacy front before British Columbia, but when British Columbia brought its in, it actually advanced the case and brought in order-making authority. I think every case will be different, but an area again where I would say we're behind in British Columbia would be on mandatory breach notification, and I don't frankly think that would take a considerable amount of time in advance. It would take a little bit of time just for organizations to be made aware, and also for the regulator time to get set up, because that obviously will increase the demand in our office. So I don't think there's any precise science about it. It could be a matter of months. But a lot of these things, of course, are well known in the business community already, and businesses are already having to comply, for example, in Quebec or across the rest of country, or if they're doing business in Europe internationally. So these are standards and benchmarks that are been pretty well established, and again, I don't think are going to come as a great surprise once hopefully Canada, federal government, raises its game here.
Thank you very much. Merci beaucoup. Je passerai maintenant la parole.
Thank you. Now, Mr. Lemire for 2 minutes. Thank you, Mr. Chair. Ms. Poitras, Mr. Terrien, the former commissioner to the protection of private information, mentioned that the federal and provincial commissioners collaborate on various subjects when it comes to non-compliance. Do you believe that the inferior standards by C-27 could influence this matter if we don't go? If the standards are not the same in Law 25, if we are not aligned with the standards of Law 25? Answer: of course, there should be harmonization. My colleague, Mr. McAvoy, mentioned it in his statement. Yes, there are obligations. In terms of foundations, we are able to collaborate. We are able to take joint actions, and there are some nuances. There should be also harmonization in the powers that we have, the powers to order making, powers to levy fines. This administrative financial fines ability is also in an incentive so that businesses can quickly bridge a gap if later. So this is something that will not work. We're trying to incentivize so that businesses can be compliant. Our collaboration is excellent at the moment, I should say. Thank you. Relative to AI, you mentioned earlier that you were in favor of high standards, contrary to a voluntary code of conduct, such as decreed by Jean-Philippe Champagne, Minister Jean-Philippe Champagne. And this is also stronger and stronger in other parts of the world. Are you concerned relative to the setting up of trust creation, that it should be voluntary rather than so that the highest standards can be adopted by a group of countries in the world? In Quebec, the Declaration of Montreal was a voluntary code. And I think it's a step in the right direction. It's normal to go step one. It takes time to adopt the right law, to find the right balance. However, I believe that collectively, with all of the concerns that were already raised, in terms of some applications of AI, not all of them, of course, there's many benefits to using AI as well. I think collectively, we are at a stage where we should be imposing binding rules and also to introduce some systems that are unacceptable because they are going against our democratic principles as a society. Thank you for being here today. Thank you, Mr. Lemire. Sir Massé.
Thank you, Mr. Chair, and apologies to Mr. Viss. That was me that created the commotion. I was excited to be back at industry here, and I have a loud voice, as people know, so I appreciate my colleague here. I do want to say to Mr. McAvoy, your privacy laws in the past and as well as civil liberties coming out of British Columbia have been very solid over the years, and just wondering, at this point in time, would you have a recommendation if we only did part of the bill right now? So if we did the privacy component first and then worked on the AI stuff later on. There's a lot of witnesses that have come here saying that we should scrap the whole process. Some are saying we should get on with it. We're getting a lot of mixed messages, and I'm just wondering, and when I had made a motion with the NDP to actually split the bill into two segments of voting in the House of Commons so that, because I understand why the minister did put them together. There is logic for that, but at the same time, there's a good case for the bill to be a little bit different. So if we were to walk away with this with just the privacy component done, do you have any comments on A, is that important enough to meet the test of metal to do that and get that done right away, or should we still continue to bundle up and maybe not get the privacy stuff because we may not be able to get the whole bill done?
Well, far be it from me as an impartial officer of the legislature of British Columbia to be giving you political advice about how things should proceed. But what I would say in general terms is the bill represents an advance for the privacy rights of Canadians. Is it perfect? No. I think Commissioner Dufresne has really articulately expressed this view that there are improvements that need to be made, but there are advances here, and it's important to acknowledge those. And we would hope that those would move forward. And again, we are trying to be helpful here today to make suggestions to you as to how that can be further improved. And that we've talked about the AI front and notification provisions and PIAs being associated with high impact mechanisms of AI, but it's also about things like protection for children's rights. And again, we would support the federal commissioner in his bid to have those strengthened. So in general terms, these are an advance, and that I think needs to be acknowledged.
I just got a minute here, but now if political parties were included in the federal bill, would that mean that you'd have to look at coordinating with the provincial side? I understand some of the reasons there's an opposition to the federal applying is that you could have different standards across different provinces on privacy, making it difficult. So what would happen with regards to substantiating, I guess, it would have to be at least equivalency to BC? Is that kind of the position that would the expectation be on the federal if we included political parties?
Well, the thing is, if political parties are encompassed within federal legislation, that would then provide a mechanism for Canadians to take whatever concerns or complaints they might have, presumably to the Federal Privacy Commissioner for adjudication. And again, I can't express this strongly enough. That would substantially enhance the confidence and trust that Canadians would have in having that dialogue with their parties, which is so important at a time when democracy is so fragile, that that trust be strengthened. And that can only be helped through including political parties within federal privacy legislation.
Merci beaucoup, Monsieur Massé.
Thank you, Mr. Massé, and thank you to our three witnesses today, Mr. McAvoy, and our two other witnesses. Thank you very much. for taking the time to speak to us this afternoon. This will be the last meeting of 2023. If you must leave, you are welcome to do so. There's 2 motions to approve. Thank you very much for taking the time to be with us this afternoon. Much appreciated.
Thank you.
Alors, j'ai simplement 2 petites motions pour adopter les budgets.
There are 2 motions to adopt the budget of the committee. The first one is as follows.
Of the recent investigation reports on Sustainable Development Technology Canada, the proposed budget in the amount of $7,250 be adopted. Do I have unanimous consent? I do. Et finalement, que relative
And that in relation to the committee's study of use of foreign workers at the EV battery manufacturing facility in Windsor, Ontario, the proposed budget in the amount of $7,250 be adopted. Do I have consensus? Thank you very much. And therefore, without further ado, I will suspend so that we can come back in 5 minutes with the second part of our meeting. The meeting is suspended.
Chers collègues, on reprend.
Dear colleagues, I call the meeting to order. We would like to speak now to the SDTC. We are currently at the fourth and last step of the motion. I'd like to welcome our witness today, Annette Verschoen, who is here by video conference. Thank you for being here this afternoon, this evening. Ms. Verschoen, you have 5 minutes for your opening remarks.
Good afternoon, honorable members. My first role out of university was as a development officer in Cape Breton. I focused on creating new opportunities as the mining industry in the region shut down. I brought this same focus to my role as CEO of Home Depot, where we successfully created 20,000 new jobs nationwide. I am now focused on helping to realize the potential of the clean tech economy in Canada. This passion led me to found EnerStore. I am proud that we are the co-developer of the Oneida Battery Storage Project with 6 nations of the Grand River. Together, we are creating the largest battery energy storage project in Canada and one of the largest in North America by an Indigenous-led project. In 2017, EnerStore received $2.1 million in funding from SDTC for its Goderich project, a partnership with HydroStore. This was the first in the world commercialization of long-duration compressed air energy storage. 2 years later, in 2019, I was approached to serve as SDTC's chair. I informed the minister, the deputy minister, and the ethics commissioner that I was the CEO of EnerStore and that the project had received SDTC funding in 2017. I accepted the appointment after completing my full disclosure and conflict of interest review. Let's be clear. My direct involvement in the clean tech industry was precisely what Parliament intended when it created SDTC in 2002. Section 11 of the Founding Act of SDTC requires board members to be people with direct knowledge of sustainable development technologies. As a public member of numerous boards since I was 38, I am extremely familiar with conflict of interest policies. I recused myself from the discussion and vote regarding 14 companies when they were real or perceived conflicts of interest. I had no direct or indirect investment in any companies funded by SDTC other than EnerStore during 4.5 years there. Not only did Parliament want people with expertise on SDTC's board, but its choice to enshrine this in its founding act has worked. The board and its sector expertise have helped make the right investment choices. On the recent Global Clean Tech 100 list, there are 12 Canadian companies, and 10 of the 12 received funding from SDTC. We are punching above our weight. I believe the success of the projects SDTC has funded demonstrate that the board under my leadership has done a lot that is right. I resigned as chair of SDTC's board on December 1st, not because I have done anything wrong. I believe the organization's work is too important to be compromised by the distraction that these allegations have caused. Board processes can and should be reviewed and updated from time to time. Renewal and improvement are both good things, and we did this routinely at SDTC. Now, think back to the early days of COVID-19. The World Health Organization had declared a global pandemic. The borders were closed. We were terrified of the impact on the clean tech sector. The young organizations in our portfolio needed our help to survive. If they did not, the incredible talent and know-how vital to Canada's future would be lost. Under the COVID-19 emergency payments, no company received preferential or different treatment from any other company in SDTC's portfolio. This emergency funding was entirely different from the initial approval of individual projects. These projects had already received funding, in EnerStore's case, since 2017, 2 years before I joined the SDTC board. As a board, we received legal guidance that granting the envelope of emergency funding to already approved projects meant no individual board member was in conflict of interest. The legal advice is recorded in the board minutes. In approving emergency funding to all 126 companies in the portfolio, the board did not consider or discuss any companies individually. We did not even have a list of the recipients when the vote was taken. We acted in good faith. Our entire focus was on the well-being of the portfolio companies during an unprecedented global crisis. At that time, we were lauded for taking proactive measures to help secure these companies' future, including a thank you letter from the minister. To be clear, the $217,000 Enerstor received as a COVID payment from SDTC was directly invested in the Goderich project, a limited partnership distinct from Enerstor itself. These monies are accounted for as part of the project, and the expenditures were verified by audited statements prepared by PwC. No money went to me or my salary. In fact, I did not receive a salary from Enerstor in 2020. This is the true nature of Canadian startup culture. I truly believe in the potential of the clean tech sector to create jobs and transform our economy. This is what drives me. Thank you, and I'm happy to take your questions.
Thank you very much, Madam Verschoren. We'll now start the conversation with MP Perkins for 6 minutes.
Thank you. Ms. Verschoren, you were handpicked by the Prime Minister, I think, as you said in your opening remarks, right, to do this job?
I was asked by the Minister of ICID at the time.
On June 9th, 2022, the Annette Verschoren Centre was granted $2 million from ACOA and an additional $2.5 million from NGEN. NGEN is a industry department funded organization, got $177 million from ISET. So that's 4.5 or 4.2 million, I should say. You got the Annette Verschoren Centre got on that date. Is that correct?
The Annette the Verschoren Centre is named after my parents, Tony and Annie Verschoren.
It's called the Annette. I'm sorry, it's called the Annette Verschoren Centre, and I didn't ask you the history of it. I asked you if it got that grant.
It's not called the Annette Verschoren Centre. It's called the Verschoren Centre, and that Verschoren Centre is a non-for-profit organization that has created an amazing amount of jobs in Cape Breton.
You're denying that they got the grant?
Mr. Perkins, just let
I asked the question. I have limited time, and she's ragging the puck.
I'm certainly not ragging.
Yes, you are. Answer the question,
Point of order,
please.
Chair.
Yes, Madam Khalid.
I think, we do have the member here, the witness here. We would like for everybody to have a cordial conversation and make sure that we're not harassing anybody.
Yes, I agree, Mr. Perkins. I'll just ask you to, we can have a robust but respectful conversation and let the witness answer. As you've known me for some time now as chair of INDU, I'm somewhat lenient on time, and I can be liberal if witnesses take longer to respond. So I can be mindful of that. I just appreciate that we have a respectful conversation. So
did the Verschoren Centre?
I'll give it back to you, Mr.
Did the Verschoren Centre get $4.2 million on June 9th, 2022?
I don't know the exact number, but it got contributions. Yes, it was in 2010 when that was established, and Peter MacKay was there to open up.
Isn't that great? September 5th, 2023, the Verschoren Centre got another $1 million from ACOA. Is that correct?
Not sure, but I'm sure that it is an organization that's really supported because it's doing tremendous.
It seems to be supported enormously by the Liberal government. On September 19th, it got another $3.1 million from the industry department. Is that correct? That's a total of $8.3 million in 1 year. Is that accurate total?
I would say that the monies that the Verschoren Centre got, the first tranches were under the leadership of Stephen Harper, and these more recent tranches are under the leadership of the existing government today. Yes.
Got the 8.3 plus another 1.4 million from DFO in May 2022. So that's a total of almost $10 million in about a year and a half. So I want to ask you this question. When the SDTC Investment Committee considered your proposal or the proposal from the Verschoren Centre for another $2.2 million in 2022, did you think that was a conflict of interest?
I'll tell you, I declared that as a conflict of interest. Absolutely, right up front. And the way it works, every time there's a project that comes forth, the board of directors declare conflicts, and they don't receive the material that is given in the board books. They recuse themselves from the meeting. They do not get involved in any of the decision-making processes. That's how the decision works.
So now I'll just remind you under oath, and we had a whistleblower here last night. Did you send any communication before the investment committee asking the status of that project to management?
Honestly, I don't recall.
Oh, that's convenient. So let me help refresh your memory. I have an email from the VP of Investments that says, in fact, that this project was fast-tracked going forward. And the testimony from the whistleblower last night was that he will provide us with emails showing that it was fast-tracked, which was highly unusual. So you're not aware that it was fast-tracked, or you're saying you don't recall ever making representations on behalf of the centre?
Because this was a conflict, I would have limited my discussions on any of this.
Well, apparently it didn't stop it from going through the process and coming forward and having to go all the way to the investment committee. So in addition to that, after it was rejected because of your conflict of interest, are you aware that the staff was told to find other financing for your centre?
No, I'm not aware of number one, I think the process worked, right?
Well, let me refresh your memory. The minutes of the project review committee from SDTC, I say right here, where it was rejected, said, SDTC will shift its efforts to discussions with other potential funding sources with the hope that the diligence conducted today can be transferred. And then the centre received almost $10 million after that. Seems like it pays pretty well to be a well-connected Liberal who got appointed to this. Now, Andre Lise Mateau also got almost $40 million to things that she had an investment in, and then got shifted to the infrastructure bank, and on that sat on the investment committee that gave your business $170 million. Isn't that correct?
Look, we're entrepreneurs. We are investing in the future of our country. We are.
If everything's dependent on government money.
It's not. Every $1 spent by SDTC creates $7. It's an amazing, successful organization. And I'm going to repeat.
It's been successful in getting money off of it.
Mr. Perkins, your time is up. I'll just give a couple seconds to the witness to respond.
I just would like to say that look, there are many of us that are in the clean tech sector. This is a tough sector. It is not easy to develop projects like we are developing. And Andre Lise Mateau is a maverick. She really understands, and she's someone that I have a lot of respect for. Has invested aggressively and really built companies in Canada that create jobs that are part of the future of the growth of our economy. We need companies like in the clean tech sector. Those 10 of the 12 companies in the global list of companies are Canadian companies. One of which, by the way, is
Okay, thank you, Madame Verschuren. I'll now yield the floor to MP Sorbara for 6 minutes.
Thank you, Chair, and good afternoon, Ms. Verschuren. If I mispronounced it, I do apologize. Annette, just going over everything, my understanding is you served and you were appointed from 2019 till the end of 2023, correct?
No, until, what was the date? December 1st. One of the things that I really wanted to do was the management response and action plan. I wanted to be able to complete that as the chair of STTC and hand it over to the ISET officials, and we did that together.
I just want to get on the also have on the record that you have served in different capacities in your lifetime of your curriculum vitae, your experience, or whatever term you want to serve. You also have served on the National Science and Technology Committee for Prime Minister Mulroney. You were on the North American Competitiveness Council for former Prime Minister Harper, and you also served for, God bless him, his rest of his soul, for former Finance Minister Jim Flaherty as an economic advisor during the economic crisis in 2008 and 2009. Is that not correct?
That is correct.
All three of them?
Yeah, all three of them.
Okay, well, first of all, I wish to say thank you for your service to all governments that have been in power, obviously built upon your experience and history within the business community, so thank you for that. Secondly, you obviously, or I wish to also put on the record, with regards to your history of donations, my understanding is you potentially have or did support Jean Charest, a Conservative leadership candidate in last year's campaign. Is that correct?
That's correct.
Okay, and also understanding that the profile is public, is that you donated the maximum amount to his campaign.
Yes, I did.
Yes.
Yes. I vote for. I vote and support individuals that I think can make a great contribution. Christine Elliott. I'm nonpartisan. I have. If you take a look at my record, I think I vote broadly.
Okay. There's progressive conservatives are there's still some around. It'd be great if there were more around. It doesn't seem like they're not welcome in some parties these days. And I think we just heard some chirping from the backbenches and the real backbenches about not welcoming progressive conservatives in the Conservative Party. But nonetheless, we'll continue on. The next thing is obviously if any other MP has donations to make to other individuals, that does not make them an insider. But Annette, moving from there, you've been around business for a long time, and recusing yourself from decisions. How do you feel about that when you were with SDTC in terms of recusing yourself from decisions which may not be viewed at the time as having conflict of interest or potential conflict of interest or anything like that extent, but which may in hindsight you may have excused yourself and the same decision would have been made?
Look, I understand business. I've been on boards for almost 30 years. I take responsibility and governance very seriously. I am chair of a governance committee of a major company in Canada. I understand.
Okay. It appears that we lost a witness. We'll try to figure out the reason, and I will then suspend the meeting until we get a hold of Madame Verschoor. Meeting suspended. Meeting is back in session, and given the hour and the limited resources that we have for this meeting tonight, it appears that the witness has had technical difficulties and has not been able to reconnect with the committee. Hence, the witness will be re-invited this Thursday. I will ask the clerk to re-invite the witness. Je vais demander à la greffière de réinviter la témoin pour ce jeudi.
I'd like to ask the clerk to re-invite Mr. Lemire. Thank you, Mr. Chair. Could I have precisions on how will the witness be brought forward? I don't want to prolong too much, especially in the current context. Is it a convocation or an invitation to formally witness next Thursday? As far as I know, there was no reluctance from the witness to witness. We don't need to call the witness. She was available to witness today. And what I understand is that these were difficult. There were technical difficulties. So we will re-invite her this Thursday. I know that Madam Clerk will work on this today. Thank you.
Est-ce que, bon, mais dans ce cas,
in this case,
this meeting, and see you on Thursday. Meeting adjourned.
Au cas où,